All right. Today we have a guest presenter, Jeremy Wood. Welcome to our board, and we look forward to hearing what you have to say.
Rex, are we on? All right. Well, thank you all. Thank you, Madam President. It's a privilege to be here. Um, as was noted, my name is Jeremy Wood. I'm a employment defense attorney at the firm of Fisher Phillips, a few blocks away from here. I used to give this training for several years to the Department of Enterprise Services, the DES, and through them to managers throughout state agencies. So I don't think there's any circumstance that could be presented today that compares to the Department of Corrections questions I've gotten in the past. I also am the former chair of the Seattle Human Rights Commission, and through that served as a appellate ALJ for discrimination complaints that went to the Office of Civil Rights. And so I've engaged with these issues from a number of vantages. I know a couple faces here today. I'm grateful to meet new ones. My hope is, for those who have or have not encountered these claims, in practice, I don't think the law at a high level is that complicated. My hope is that this gives us an opportunity to talk through situations and how you as BOG members or as attorneys in your practice and in management of within your offices can serve to further and inculcate workplace cultures and a culture throughout the WSBA that doesn't have space for harassment, whether sexual or of any other kind, or for discrimination or retaliation. So I'll start, Rex, if you want to throw on the first slide, and then we can move in a second to the second. So one reason why this matters and the reason why I get called in is that there can be a lot of money on the table with these lawsuits. My hope is that that's not the focus of this or our concern for these issues, but it is a reality. Some of the lawsuits up here are still ongoing. So lots of money, they can pop up in a lot of ways. And so we do on occasion see lawsuits filed by folks whose identity is not necessarily marginalized in our broader society. So we see this white Seattle city worker. Sometimes those lawsuits have merit. Sometimes they don't. But they can pop up in a number of ways and they can carry big price tags. But I think what is more important, obviously, if we can go to the next slide, Rex, is the well-being of those around us, within our offices, and within the membership of the WSBA. And through that, the citizens of Washington who are impacted by the actions of our members and our board. All of you, obviously occupy a position of grave responsibility. I don't know everything that's been on your agenda today, but it is certainly the case, and I think that all of you will be remembered. I'm sure for the good work you do. I know that in past generations of the BOG, there have been issues of harassment. I think this is a very different board. I'm very grateful to see. I think it's been a very different board for several years. But it is still a reality that this follows you and is worth vigilance. So today we'll talk a little bit more about those reasons. We'll talk about, Rex, can go to the next slide. We'll talk about the legal framework that we're operating within, and happy to at that point or later on or at any point address any questions, and hopefully not so much as a talking head, I have played that role, obviously, for when I'm training more on the HR side, but I'm certainly hopeful we can have an exchange and dialogue across this table. So we'll talk about that legal framework, and then we'll talk about a five-step plan that's been worked out in the past with between the WSBA and my colleagues for ensuring a WSBA free of, I shouldn't say ensuring free of, that might be beyond our power, but as free as we can make it of discrimination, harassment, and retaliation. And then we'll talk about some situations and how you might act or choose to act within those. Next slide, Rex. So obviously the most important reason is, I mean, empathy feels like an understatement, but an acknowledgement of the harm that sexual harassment, that other discrimination causes. I think that we all live with an intersectional mix of identities. I certainly don't want to make any assumptions. I know, even though I am a cis heterosexual man, when I've suffered discrimination based on the more marginalized components of my identity, it hits at a very deep level that's hard to really articulate. The humiliation of being seen as less for who you are. I think that we can understand that from a position of empathy or a position of experience, but either way, I think we can all recognize how serious this stuff is. It stays with people throughout their careers. It certainly stays with people throughout their interactions. Certainly true of sexual harassment that devalues someone's full humanity and contribution, and commodifies them in a way that is hard to come back from for either victim or organization. And the WSBA obviously is committed to access to justice in many ways. That includes court reform, professional reform, but it also starts at home in our workplaces. Next slide, Rex. So like I said, lots of money. I don't really need to push this one too much with all of you. We're all lawyers. We all know what a pain litigation can be for our clients on either side of the V. And I also can't tell you, just like I can't tell clients that there's ever a absence of risk. You can always get sued, regardless of what happened. But obviously, there are steps that can be taken to either preclude or set things up as best they can in the context of litigation. We can talk about that, but I don't think that's so much why we're here. Those lawsuits, though, however they play out, impact the reputation of organizations, even if they end, I mean, in my context as employment counsel, even if they end in a full defense verdict, they still stick there. As we'll talk about, even if something doesn't rise to the necessary legal threshold, doesn't always mean that it didn't happen, and that has lasting consequences. Next slide, Rex. I think we're all also aware that an environment where everyone feels like they can be their full professional selves, where they feel safe, where they feel respected, where they feel motivated, all of that just creates a happier workplace, both for those who are directly impacted by these dynamics, but also those who are maybe indirectly, those around them who may not be targeted, but don't want to work in a discriminatory environment. And at the bottom line, I mean, there's plenty of studies out there leading to higher productivity as well. Lower turnover, whether within my clients, within staff of the WSBA, within each of your law firms. People want to, I can say as a millennial associate, I know that my generation maybe jumps around a little more than our predecessors in the practice, and this is definitely a way to limit turnover. Rex? And lastly, as to everyone as individuals, and I have learned from your president, and actually from an email from one of the WSBA's in-house counsel, you could that there was a bit of a service event this morning. You could be named in a lawsuit as employers or frankly as members of the BOG. Under the Washington law against discrimination, you can be held individually liable. And I can't say that I know all the WSBA's indemnification policies for all of you. But I know that even with indemnification, it's never fun to have your name on a caption. And you can be held accountable by the WSBA under its policies. And so taking steps before and after a complaint is important. And those steps before are not just once you learn of something going on. Obviously, those are cultural steps that take place every single day. But also go to how you handle. I mean, I think we all have something in mind when we hear complaint, but really concerns that are raised or brought to your attention. Rex? So let's talk about the law. Who is, if I could see a show of hands, who here has litigated either WLAD or Title VII or ADA claims, anything of that sort? All right, we've got a good host. And I know a couple of others of you practice or dabble in employment law, maybe not in the discrimination context. But that's good to see. So this won't be news. Frankly, it probably won't be groundbreaking to any of the rest of you. But if there are dimensions of these frameworks and these elements that do spark questions, I'd love to chat. So obviously, as we know, we can go to the next one, Rex. Discrimination, retaliation, all these individual claims generally go back to a protected class. I mean, a retaliation claim also references or depends on activity related to that class. So do a large host of other retaliation claims that we won't talk about today that are outside the discrimination, outside the equal employment world. But protected classes obviously are those characteristics that have been designated by different statutes. Trying to think if I can think of any precedent that has judicially added a protected class. I can't. I don't think that would be proper, but regardless, that have been set up by statute. And I think we all have a good sense of what those are under federal law, for sure, a narrower host. We've got a couple others under the state, and we have a number of others under Seattle city law. So before we go to the next slide, I'd love to just on a popcorn basis, if anyone wants to call out protected classes that exist under state law but not federal. Mm-hmm. Mm-hmm. Sorry? It's city.
Use your mic still, please, so that people online can hear you.
Yeah, there is a protection under state law. I'm trying to remember the language of the statute. It limits any pressure to vote one way or another. But there's a more robust protection for political ideology under city law, which we can talk about. It's tied, but it is tied for the most robust political ideology protection in the country. But others under state, marital status is one.
Gender identity?
Well, that is also recognized under federal law for the time being, hopefully indefinitely. What about Seattle? We've got a bunch in Seattle. So we had political ideology, like I mentioned, very broad. So DC, for example, I can't remember the language in their statute, but their courts have interpreted their political discrimination protection to refer to affiliation with a mainstream electoral party. Ours is anything at all. So I know a number of years ago, there was an instance of a alt-right Proud Boy guy who got kicked out of a Gold's Gym in downtown, I think in downtown Seattle, might have been Fremont. And there was a lot of discussion of whether he was going to be the first to sue under this protection. I'm not aware of any litigation. I can't say that OCR hasn't handled the Office of Civil Rights in our Seattle city government, but it's been pretty rare. Any others under Seattle law? We had one added in the last year.
Is familial status one of them?
I don't know if it is.
I think we have it in Spokane, but I don't.
Really? How has that been
Whether you
considered?
have
Like
ki-
having children?
Whether you have kids or whether you're
Interesting.
married or a single parent.
Wow. Well, that's great. I don't think we have that out here. My partner is a single mother. That's great to hear.
Immigration status?
Immigration status, yeah. Which is obviously a little complicated because then you do have I-9 requirements with employers, but short of that, short of what's preempted by that. Caste was added in the last year. And I think there's a lot of questions of how that's going to play out based on how it's defined. I mean, I think it's obviously coming from more of a South Asian background, but the statute interprets caste very broadly as really any inherited social position. So lots to be seen. But yeah, under federal law, as we noted, gender, sex, gender identity, both as to.
I think we had a question or a comment over here.
Yes, please.
Use your mic, please.
You sort of went over it though after I raised my hand, but on the caste thing, does the law define what they mean by caste? Because if it's just
Yeah.
the dictionary definition, that's
No,
I know
no.
from litigation that's really broad.
Yeah, no, it does include a definition. I think the definition still is very broad. I was very happy to be the first person to publish an article about it. So it's up there online. If you shoot me an email, I'd be happy to send that to you. But the ordinance does include a definition. I think it still has a tremendous amount of ambiguity in it.
Okay, because I'm following up because the one case I had with the state Supremes on this caste thing, it's anything, if I recall correctly,
Interesting.
it's any distinction based on wealth, social status, and if something, I mean, something incredibly broad that can capture almost anybody.
Are you saying
So,
there was a Washington Supreme Court case?
well, it was in a case I had that I lost.
Oh,
So you don't want to use the one time I lost. Thanks, Kevin.
The only one. Yeah, I know California had some litigation around it too. Yeah, please.
You kind of mentioned it, but it's the interpretation now. So under Title VII, sexual orientation is not specifically
Mm-hmm.
identified. It has been interpreted by EEOC and included. But the question is, if you're talking about the black letter law, it is not there at the federal level in the black letter law.
Yeah.
It's there under EEOC's interpretation, which
Gonna fall.
given
Sure.
recent events
Sure.
could be narrowed.
Yeah. When I also wonder I mean, without getting into politics, SCOTUS surprises me sometimes. Yeah, I don't know how they would hold that it is not included after Bostock unless they rolled back Bostock. So we will see. Absolutely. Rex, do you want to put us ahead? everything I'm saying is about the current state of the law. There's some uncertainty. Okay, so federal law, as many of us know, race, color, religion. I think the definition of religion came up a lot during the COVID pandemic. I know when I was fielding hundreds and hundreds of advice requests about people not wanting to get vaccinated for reasons that were either associated with a broader religion or about their particular beliefs about the cycles of the moon. National origin, which can include obviously native language, accent, cultural tropes that may be linked to national origin, or cultural stereotypes that can be linked to national origin. Gender and sex. We've talked a little bit about gender identity. Is at this time protected under Bostock, although there was an implied exception at the end of that decision when there's a religious basis for that discrimination. I'm not going to get into that, but at this time is protected under Title VII. Sexual orientation under EOC regulations. Age over 40. So I am a few years out from having that protected status. Disability, whether mental or physical. We've had some state case law that has expanded that beyond the ADA. For example, a few years ago, I always get the appellant's name wrong. His name was, I want to say Casey Taylor. So it was Taylor versus BNSF. Held that obesity without any other health concerns, any other comorbidities itself was a protected disability, so it can be a little bit nuanced. I put veteran status here, but active status as well, active or reserve status as well. The need to take family leave, which I mean can go to family status a bit, but goes more to protected activity. And then on the state level, we do have a more explicit protection for gender identity, marital status, family relationships in certain jurisdictions, the filing of workers' comp complaints. I know that we have some workers' comp, at least one workers' comp lawyer here. Yep, yeah. I don't know if you've ever had a case, Jordan, but I know I've seen you pop up on things in the past. The use of domestic violence leave, or more generally, status as a victim of domestic violence. There are some accommodation requirements that are a little bit ambiguous, in my opinion, in that statute. Victims of crimes, increasingly I have your victims with expunged juvenile records, but as many of us are aware, there are also limitations on in general discrimination against individuals with criminal records until certain times in the employment hiring process, and then based on the nature of the offense, so it can get nuanced, and like we've talked about, further local protected statuses. Rex, can we hop ahead? Yes, please.
So this last bullet point there with regards to juvenile crime records, and as I understand, there's been some concerns, and particularly in the hiring process of for criminal records, for adult criminal records or non-juvenile records. And one of the things, if you look at the FDIC Improvement and Control Act, I believe, which refers to banking law, there's long been, or there was certainly a proscription against hiring individuals with criminal records that have to do with crimes of moral turpitude.
Sure.
And it seemed like there was always a de minimis exception, depending on the nature and timing or whatever of the offense of the applicant. But I know with regards to over the last decade or so, there's been some kind of relaxation. Has that law been amended, do you know, because of the concerns around discrimination? On that? It just seems like that was really a fraught area, particularly with regards to some of these discrimination, protected classes and that kind of stuff.
Yeah. Do you mean our state bill or the FDIC rules?
No, the federal, FDIC.
Yeah, I don't know. I know that, for example, the recent protection for applicants using cannabis, for example, obviously has exceptions for when it's federally required to screen them or exclude them. I don't know if there's been progress on the FDIC side. Yeah, no, it's an interesting issue, and I mean, I would assume it would be. I mean, it's never great to be in a preemption space for our clients where you've got to violate one law because you've concluded the other law applies or preempts. But I think that would be, yeah. All right. So discrimination, broadly speaking, is when a adverse employment decision is made based on a protected status, and the whole burden shifting framework looks to whether an individual was either qualified to receive a job or performing their job adequately and was subject to an adverse action that was not leveled against those who are similarly situated. I think that some of the nuance here, as indicated here, is how broad that adverse action potentially can be. I mean, I think here a lot of them are fairly obvious, hiring, firing, but even in evaluation, I've seen those cases. I recently had a few months ago a charge before the HRC where someone, because they had been on medical leave connected to a disability, and they were out when company T-shirts were handed out. They said that they had not received a T-shirt based on their disability. It's one of the easiest cases I've ever had to settle. Like, no attorney's fees, and here's your T-shirt. Benefits, for example, is an area where disability can come up, where age can come up, all sorts of terms and conditions. I mean, it's not unlimited. If the T-shirt case had gone to litigation, would it have been held to actually impact the terms and conditions of someone's work in a way that wasn't beyond de minimis? I don't know. But as we all know, the merits of a case don't really always inform the costs of litigation. Rex, we can go to the next. Harassment under the law generally occurs in two ways. There's quid pro quo harassment, and I won't say anything more about what those specific words have meant in our world in the last few years. But that's where often in the context of sexual harassment, either the lack of some detriment or the provision of some benefit is given in exchange for a sexual act. Yeah, please.
Hate to bring up a subject we just moved on from, but with regards to discrimination, I know one of the protected classes was disability, whether physical or mental.
Yeah.
And I understand there's been, with regards to addiction issues, some developments over law over the last couple decades, probably, that significantly have impacted that aspect. But one of the things that I think we're seeing more of, probably, particularly as the economic circumstances have kind of pushed many retirees, pre-retirees back into the workforce, are mental, mild cognitive impairment or other minor, early onset dementia type symptoms, which could significantly affect their work performance, and therefore potentially evaluations or other aspects of their work performance. And particularly because we would be looking at potentially, age discrimination and or physical disability or mental disability, depending on the nature of it, whether it's, for example, vascular dementia or some other type of physical, affect the impairment that affected performance. how those get teased out, because, the employer's going to say, well, this individual can't do the job anymore. They're being fired because they can't do the job. And they're saying, I can't do the job because, I've got this a medical condition that's, decreasing my mental capabilities. And that seems to be a really difficult thing, particularly as we're in a, knowledge economy now. We're not, the person might be able to sling a hammer or dig a ditch or make a widget or whatever, but, figuring something out mentally might take them, half again in time. Well, so is that an allowance? If you're being paid by the hour or billing by the hour, that's an hindrance, not a, you can't, making that kind of accommodation.
Yeah.
So I don't know what you're seeing in that space. If that space is developing, it seems like it's certainly a place that is burgeoning or should be if it's not already. And I'm thinking that there should probably some developments in that area. Could you address that briefly? Thank you.
I mean, I'll say the baseline that I anecdotally in my practice and from what I've seen, we've generally seen an uptick of age discrimination claims and lawsuits. I think just as a bulk of the workforce tilts towards a certain side of the scale. As for that situation, I think that we are very likely to see that. I have not seen that yet. I think that you would engage with it like any other interactive process or accommodation consideration for disability. But I think we will see a wave of it because we do live in an economy that makes it harder for that generation to retire. Plus, increasingly likely to be in front of a judge who's on senior status themselves. So,
well, this kind of reminds me. My sister was counsel for the Department of Defense, and they had a situation, and this is a couple decades ago, I think, or sometime where firefighters, have to be able to climb a ladder, assist an individual, carry him out potentially or whatever, right? And you mentioned obesity, and if an individual, can't do that and they're physically impaired from doing that, and it cost a lot of litigation. I think there was adverse determination that the individuals had to be accommodated, but what does that do for the thing itself is public safety concern, it seems like. So
no,
there seems like some, particularly a lot of these, potential areas that are potential litigation or have been litigated. Difficult, for both the employer and the employee situation.
Well, and I'll say I won't go too much into it, but I have a fire department disability case with someone who was a probationary employee to be a firefighter. And those public safety issues obviously are huge. At the end of the day, from a legal perspective, disability is protected if you could, with or without an accommodation, perform the job. How that gets litigated as we increasingly see cases of older folks who may have dementia symptoms, I don't know. But no, I think that's a prediction that I think we want to be looking out for. All right, harassment, like I said, so one form, quid pro quo, the other in the context of a hostile work environment where there hasn't necessarily been any concrete change to the standards of someone's employment, but there's been conduct or words that are either so severe in one instance, sexual assault, or so pervasive, just an endless series of jokes no one should be making, for example, as to recharacterize the workplace someone finds themselves in. A couple of notes there, because I did recently litigate this issue. The conduct or language doesn't necessarily have to be directed at the plaintiff. It doesn't necessarily even have to deal with the plaintiff's own protected class. I don't want to say that's one way or another. The case law is a little nuanced, but just there's I think in operationalizing that, the notion is even if there isn't someone who you assume would be directly affected, which also is a broad assumption. People have hidden identities, or not hidden identities, but people have non-visible identities. People have families, people have friends. The whole locker room talk thing, I think, is something that needs to be left in the past. Those those comments in a room may impact someone, may lead to liability, but also just may lead to an environment that we don't want in the first place. There is both an objective and subjective component to that, obviously. I mean, I would assume someone suing probably was subjectively offended to some extent, and the conduct itself has to, in the views of a fact finder, be offensive. As to Rex, we can go ahead. So the BOGS policy states that engaging in any act that discriminates against an employee because of sex or other protected classes will not be tolerated. Also, a prohibition on retaliation for those who raise those concerns. And also an important point there at the bottom, this goes both for your own policy and also for the law as to work-sponsored events. I mean, if two people are informally going and grabbing a drink after work, that's one situation. Although again, I think we don't want this to occur anywhere. But from a legal perspective, if there is an off-site work event, then all these laws come into equal force. Rex, we can go ahead. So we talked about quid pro quo harassment, and Rex, we can move forward. Again, I don't think I'm have any revelations here, but just noting that certain conduct that some of us may not consider physically inappropriate, a hug, for example, standing too close, can certainly be received by others, and rightfully so. People are allowed to have their responses, and I think we need to obviously lean on the side of respecting until we know otherwise. I know that for myself as a cisgender man, I walk through the world potentially capable of being seen as more intimidating than others, and that's something that I strive to be mindful of all the time. So just things that, I mean, I think that we can on here, kisses, grabbing, I think that's obvious, but some of the others that we may not interpret that way, or we may be so used to being innocuous, just recognizing that things don't always necessarily land the way we intended and being respectful of that. Rex, yeah. So again, verbal behavior, some of it obvious, some of it the things that we all either make mistakes about or don't necessarily know. I mean, I think that I mean, we all remember in the Anita Hill hearings, there was a lot about Clarence Thomas talking about his own sexual history, not necessarily about actions with Professor Hill, but certainly comments that may have been designed to, but regardless, did make her uncomfortable. And so also an area for caution and consideration. Same thing on the visual side. Some of this obvious, maybe some of it not. I had a case coming out of a police department where one police officer who was male was on shift with a female police officer, and I can't say whether he meant this in a sexual way or he meant this in a couple cops trying to show off or whatever, but showed a picture of himself without a shirt from the gym, which made her very uncomfortable and led to litigation. So lean on the side of caution. Yeah.
I'm sorry, I just have to ask a question.
Please.
You know, is there defense to these about being like a public figure? I mean, we just saw our president-elect fillet a microphone at his press conference 3 days before the election.
Sure.
I mean, so I mean, I'm just looking at gestures and I'm thinking,
Yeah.
you know, what is there defenses to it? I mean, and what is the what is the parameters? I mean, a gesture like throwing someone the bird, I mean, I really am curious in today's world where we're going with when we just saw so much that is now being wrapped into normal.
Yeah, yeah. No, I think it's a great question. I might not have a great answer. I think a lot of the gray area is for judges and juries. So I had a case I mean it's resolved now, or it's been dismissed now, so I can say it was for the Jefferson County Prosecutor's Office. Former prosecutor had sued. And also, like I had mentioned, was one of these cases where, although sexual harassment alleged was not directed at her, it was consensual between two colleagues, and she happened over here a couple of times. And the sexual harassment, as she described it, was one of these colleagues saying to the other, who was her friend, who they were close, these two were close, kiss my ass. And I don't think that liability should have laid there. It was ultimately dismissed by the court, but it was also filed and took 2 years to get to that dismissal. So saying there are black letter limits there, I can't. At the end of the day, the law describes severe and pervasive conduct. And I think it's going to have to go to a fact finder. I mean, I think that the example you noted, that if someone were to discuss that recent episode with the microphone, I think you'd obviously have the defense that we're just talking about politics. But how that would play out, I think, goes to the fact finder. Yeah. Yeah, please.
I mean, just in the example of what we're talking about,
Mhm.
and in all of this, because we're talking about harassment, doesn't have to be a definable target.
Mm-hmm.
So, for example, for what the person did with the microphone, he's doing this in front of a huge
Yeah.
crowd,
Yeah.
as opposed to if one can remember Clarence Thomas's nomination,
Mm-hmm.
when it was just him and Anita Hill, and he was
Mhm.
talking about pubic hair on the
Mm-hmm. On the Coca-Cola.
on the Coke bottle, but
Yeah.
on the Coke can or whatever.
Yeah.
But she was the only person. So there was a defined audience,
Mm-hmm.
as opposed to, what we don't have here is vulgar behavior, en masse.
Yeah.
So, I think that's probably where that has to go, because I think it's like, so who does it? Now, I guess it would be interesting if somebody in the audience said, I just found this so offensive. But I think the immediate response would be, I didn't even know you,
Yeah.
who are you? Who are you?
Yeah.
This was not directed to you specifically. Another example is the difference, if one may recall, in the Rose Garden, there was a press conference, and this same person, while he was president, looked at an Asian woman
Mm-hmm.
and began to say, you ought to tell China or whatever
Yeah.
what to do. And I mean, the reporter was totally offended, but there was a definable
Yeah.
target where he had singled out, this person,
Yeah.
sort of as an example. It's kind of like they're eating the cats and dogs, but I think that's different
yeah,
from
yeah.
going to somebody and saying, well, I think you're Haitian, and what dog or cat have you eaten lately?
Yeah. I mean, I think yeah.
So last night we had a dinner and there were 6 tables.
Yeah.
If I'm at my table and I'm talking to Governor Price and Governor Dresden,
Yeah.
and we're engaging in conversation that amongst the 3 of us is perfectly acceptable. We are all consenting
Sure.
to it and we're all engaging in the same thing. But the people at table 2 are hearing it. And the conversation is, and again, this is purely hypothetical, that, the conversation completely inappropriate, worse than locker room talk.
Yep.
Is there the third party claim of you? I wasn't directing it at you, but you're hearing me say these horrible things about insert whatever group would
Yep.
be so egregious as to rise to the level of it. I'm in public. Well, I'm not in public. I'm in outside of my home,
Yep.
but I'm at a private invite only dinner. I'm talking to people directly in front of me at my table. I'm not talking to you over here at this table, but I'm being wholly, and let's just say that there is the law that the actual word spoken is in violation.
Yeah.
But I'm not directing it at you.
Yeah.
So what is the defense or is there a defense of you were eavesdropping on a conversation that I wasn't talking to you, mind your own business, or it doesn't matter. So you're in a place where you need to not say stuff like that.
So there's a lot of points here. I mean, I think there's there's obviously our thinking about the individual who would not be named was not in an employment setting. But if we were to imagine Jassy, for example, being in front of a giant conference room of Amazon folks, I think that a lot of these rules would apply. I mean, I think about the classic example, which I hope doesn't really happen in any workplaces today, of the person who sends a joke or cartoon they shouldn't be sending and sends it to all the office, and then it's kind of to everyone, but it's also kind of to each individual. I think to the eavesdropping situation, I think there's a difference, and I think many of those cases there's a good chance for defense if it's just a consensual conversation. But I think the key element that you raised is there's a difference between, for example, if I'm in my office having a consensual conversation with a colleague, and we're particularly loud and no one can escape it, they're gonna overhear us, versus someone who comes over to eavesdrop, for example. And there are cases more of that nature, where someone comes and opens someone's private office door and they're doing things that are inappropriate. It's like, well, you came over. Where I think there's a difference between, hey, we should have been considerate as to who could just naturally overhear, with we were considerate and this person interjected themselves, and that gets into, I think, the consent dimension of some of these claims. Yeah. But a lot of gray area for sure. But I mean, as a general rule, that third party claim does exist.
Well, in some of these examples we're talking about, so again, in the employment context, if somebody overhears and what they're saying is, this makes me feel comfortable, and they go to a manager, an HR director, but they go and they make the complaint that this behavior is going on.
Yeah.
And I'm finding it offensive and I have to come every day. I think that turns then on what the responsible official does. And of course, if the responsible official either goes down this path of, they have a First Amendment right, or they're just, the person is being blown off.
Yes.
I think that's when they show up to your firm or somebody and says, okay, I'm done with this, because I actually did identify what was going on. I said who it was. I explained how I was offended by it, and you, employer, did nothing.
Yep. And then, assuming obviously it's connected to a protected class, once you have that notice, definitely different ballpark. And also opening up potential liability for a retaliation claim, depending on what happens next. Please.
The cartoons, I mean, and particularly the First Amendment kind of playing in this. for example, the Charlie Hebdo situation,
Mhm,
clearly that was for publication in a public thing. France, they got different laws against
Yeah.
whatever, but in the US, I mean, clearly that would be offensive to, individuals of Muslim faith, and, that type of situation. But again, the US has got First Amendment protections, and it, whether or not that was, so does an employee have a problem with the editorial cartoonist or the editorial board that published it or that kind of stuff? It just seems to me like there's a lot of different potential issues, particularly around like cartoonists or editorial or folks who are paid for their opinion, and part of the thing is a reasonable person, right? Is a reasonable person offended by it, or are you, it's kind of you find your plaintiff as or whatever, so it just seems like a really area where there's a potential, a lot of risks and then a lot of defenses potentially or whatever, depending on the circumstances.
Yeah, and that's obviously not going to be the case with private employers in Washington. There are states that have free speech protections within the private sphere. I want to say Connecticut is one. I may be mistaking it for another state, but we certainly don't. But that is not here, right? This is the WSBA. It is a quasi-governmental entity, and so that is a balance that has to be struck. Please.
This may not be the right time for this question, so feel free to say, I'll address that later.
Sure.
But I know, we're talking about an employment context, and here we have a mix of people holding different roles. We have employees, we have board members who are not employees. And I'm curious if you could just speak to the relevance of that to some of the stuff we're talking about in terms of, what do board members need to be thinking about when they're interacting with employees? Is it different than what they need to be thinking about when they're only interacting with each other?
Yeah, no, that's a great point. I mean, I think it's going to depend on the nature of the conduct. I mean, I think as a general rule, we're talking about principles that hopefully we're following regardless of the law. But I mean, like I mentioned earlier, under the WLAD, all of you could potentially, and this may have been settled and I haven't seen that case, but you could certainly be seen as supervisors for purposes of individual liability to the extent that you collectively supervise the WSBA. And so interacting.
I mean, but it's very clear we have one employee. The board supervises the executive director. So if I harass Sarah here, but I'm not her supervisor. I have no direct authority over her. So, I mean, is there in this area of law an impugned that because the fact that we supervise the executive director and she then is the boss of all the staff, is that something that's in there? Because, I mean, I'm pulled to just harass her on a daily basis. And
well, that's between you two.
I have been feeling free to do so because she wasn't my employee.
Yeah. I mean, a lot of it goes not necessarily to direct supervision so much as hierarchy. So yeah, it would flow downwards.
Even if our hierarchy is, I mean, we're here, and they're not under us at all.
So, Sarah, do you report to the executive director, and the executive director reports to the BOG? So, in that instance, yeah, it would be potential supervisory liability. Yeah.
And also, no, I mean, also wouldn't part of the issue be that we have a responsibility to protect Sarah, and as an institution, we are not.
Yep. Well,
And that responsibility is not just you have the responsibility, but actually the Board of Governors has a responsibility. And the Board of Governors has a responsibility not only for the ELT, but also as a governor, how we treat any employees of WSBA. Because of the very policies where we say, thou shalt not do these behaviors. But since I'm a governor, that's different.
Well, also, if I can briefly say to your point, Also, if you are aware of something and you take conscious action to either push it under the rug, or simply if you're aware of it and are in a position to act and don't, there can be individual liability. Please, sorry.
Well, and this gets back to my other question, and I really appreciate and agree with your point. I don't think we need to be anywhere near the gray zones. We should be running from the gray zones. We should be in the blue zone. But I assume the institution also has a responsibility to protect our volunteers. And therefore, if there's harassment or discrimination occurring among volunteers, even if no employees are involved, that still seems to be a significant problem for the organization.
Yep, absolutely. They would still enjoy those particular protections.
Well, one of the other things too is that if we look at our roles, I mean, we're indemnified. However, if your conduct is illegal, or if you're, then indemnification is not going to cover you. So, you know, it's a real tricky situation where, you know, if you're a particular situation, for example, with the, you know, First Amendment right or a reasonable defenses, what would a reasonable person, blah, 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 you know, and you're trying to make that determination and then you guess wrong or whatever, you know, and then you thought you were indemnified and you're not because, you know, guess what? This is, you know, different, and you weren't abreast of the change or the distinction. So it could be a really tricky place, especially I think for the governors in that regard.
Yeah, absolutely. If I can just ask for a time check, we have 15 minutes. Okay, great. All right. I don't know if we're going to get through all of this, but I think that's a good thing. I think we've had some good discussion. 2:30. Okay, excellent. All right, so we can move on to the next. Also noting, as I've mentioned in a couple other places, that the discrimination based on stereotypes connected to protected class alone is unlawful, whether discrimination, retaliation, harassment. So if an individual, for example, treats some women different than others based on how they conform to gender norms, and that can carry through to plenty of other protected classes. And so just an important caution that ideally doesn't need to be said to treat people as individuals. Rex? As I noted, actionable harassment can take place, I mean, increasingly virtually. Also ideally, when it happens virtually, it might be harder to track, but it's also better documented, which I've had in a few cases. Obviously at the workplace, at work sponsored events, but in a way that isn't necessarily as actionable in non-sponsored events, but also I think we're aware that harassment can occur anywhere and needs to be prevented in those places. Rex? So here's a distinction between BOG policy and the law. As I noted before, harassment in the context of a hostile work environment claim only kicks in or only becomes actionable when it's shown to either be sort of severe or pervasive. That is not the WSBA standard. As you mentioned, in the interest in not being in the gray area, the WSBA, as with many employers and hopefully most organizations, does not tolerate harassment regardless of its degree, and provides for corrective action in those contexts. Rex? So here's kind of what we were talking about. I think that that some of these I think are obviously bad excuses. The joking, right, and or I'm a good person, but I think that or the First Amendment point there. but I think that a couple here, that sort of equal opportunity harassment, just don't be a jerk in that context. I mean, I've made the argument, and there are cases that say that being generally unpleasant is not necessarily a basis for liability, but certainly can be. The consent area is hard because folks want to be able to talk with their friends where like those individuals are both engaging in that. Sometimes that consent might be apparent, but not real to the extent that maybe someone is going along. Certainly, when we get into hierarchical relationships, subordinate may want to show that they're going along, aren't offended, whatever, and may certainly be. But also we have that the eavesdropping situation. Would I defend a case like that? Maybe. Would the employer prevail? Maybe. But there's risk. So I think just measuring even those conversations within the workplace. All right, let's chat about some problems. And like I said, I've had the situation of training DOC managers where an inmate gender transitions and is now getting beat up in the prison yard. That is not going to be this hypothetical. All right. So you overhear two employees on a break calling each other culturally insensitive names, or insert one of these other sort of consensual conversations. You know they're friends, you know they're joking, neither of them is complaining to anyone. Would you consider this unlawful harassment? Or harassment in violation of BOG policy?
I'm gonna say yes because other people can hear it.
Yeah.
On the like a violation of BOG policy, unlawful. I don't feel cool to say, but I'd probably talk to them about it.
Yeah. 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 Yeah, I don't think it's I mean, especially someone who's implicated in those terms, like I'm not going to tell them how to respond. But for someone who may not be, but still recognizes it as offensive, maybe a like, yeah, not the time, not the place. Don't do it. Yeah.
I was just gonna say that's when it's especially important to say something if you're not who they're
Mhm.
talking about and people assume you're not going to be offended. They're not talking about you, but that's exactly when it's really important to say
Yeah.
something.
Yeah.
You know, as a white person, I suffer less consequences for bringing things up like that than a person of color would.
Yeah.
Men versus women, same thing.
Yep. No, I totally agree. And also, I mean, to the extent that some of us might have privileges, but have loved ones who don't, like I mentioned a few times, like acknowledging that I'm a cisgender white guy. I have a parent who's trans from an indigenous family. And so those comments both impact me in a certain way, but I also have that power to step in. Yeah. Is there anyone who does not think this would be a violation of BOG policy, of WSBA policy? I see no hands, and I would agree. All right, Rex. All right, what about outside work? What if let's say you're going after work to catch a drink on your own, or someone who's not one of those two, and you overhear two colleagues on the other end of the bar.
Is this like a work thing, or is it I just happen to see two people I know?
Let's say not a work thing. Let's say it's like downstairs in your office building. It's like it's your water and coal. Yeah, it's Cheers.
I'll take the risk and say then I don't think it's unlawful. And I probably wouldn't, if it's two friends that I just happen to know from work, I probably wouldn't say anything.
Yeah, I think it's a gray area in terms of the law. Yeah, please.
I mean, isn't the bottom line, at least to me, on the prior one and this one, is you're just playing with fire.
Yeah.
And you just tell your compadres, look, you don't want to get burned. I don't want to get burned. None of us in WISPA want to get burned. So just stop playing with fire in public, period. Done.
Yeah. Yeah.
So Tom, in that example, and I'm looking at the one happening in the restaurant, and you tell me that, and I tell you to mind your own damn business.
It seems like one of the.
Still doesn't mean I'm not playing with fire, right? But
I'll see you in court.
It's
No,
just-
no, in all seriousness, I think there's at least especially after Tuesday, just arguing with people and being self-righteous about things, I don't think is productive.
Right.
I think explaining, look, we could all get burned by this, and I'm not telling you what to do.
Yeah.
I'm just saying we're all at risk when you do stuff like that. And so please, we're all on the same team.
Yeah,
Yeah, it
but
seems like-
in your fact pattern, since I'm in the restaurant and actually I'm in the bar, and I probably had a few. And so as reasonable as you might be, you're invading my right to privacy with my bud now. But I want to go a little bit farther because you mentioned something about retaliation. And I want to ask you, in that example, because Tom has now been a buzzkill.
Not a protected.
And that's not new.
And hold on. And now, because where I want to go with this is that their work teams, they're informal, but we used to include Tom, but now we don't.
Thank you.
Back at work, but now we don't. And we're freezing Tom out. We're freezing him out because he can't take a joke. We're freezing him out, and he's a buzzkill, and how dare he tell me how to run my life. But my question is, and maybe that does kind of drift up, maybe Tom goes to Tara and in the example of being an employee and says, look, I used to be working with these folks, and now I'm clear that I'm being frozen out. Are we setting up, because it's not an official retaliation, but that work team has actually removed somebody from the work, starting in the bar. So the question, there's a question here. The question is, as it relates to a retaliation issue, how does that manifest itself? And is the fire now really beginning to rage?
I think there's a few points there. So squarely on that, good faith opposition as a protected activity to support a retaliation claim is pretty broad. And while the courts might say so, might not say so, is fairly subjective. I think that the fact that it was outside of work, but now is having these workplace consequences. And I'm not talking about like a truly horizontal relationship between the parties; they just no longer get along. That's a different situation. But if you're being frozen at a meetings or working groups based on what was believed to be opposition to unlawful discriminatory conduct, absolutely, I think there would be retaliation liability. I think it's a good rule to just never base anything on what happens at the bar in work, because there are broader discriminatory exclusions that can happen there. That we're going to go chat about this over happy hour, and all our Muslim and Mormon and pregnant coworkers can stay behind. But that's a broader question. Yeah. Well, my computer has died, so I'm fully dependent on Rex now. Yeah, please.
Well, it seems like, this one, observation would be that if it's happening at the corner watering hole or wherever.
Yep.
And, they're comfortable in that kind of a situation, whatever the scenario is, that you say, hey, look, if it's happening here, is it also happening in the break room?
Mm-hmm.
Or is it also happening in lunch hour or whatever kind of thing? And so, you might want to say something to caution, look, hey, however y'all carry on, that's fine off premises, off the work hour, but just don't bring it back to the office or something like that. Just to, raise their awareness
Yeah.
and consciousness of their own behavior, self-consciousness, I guess, if you will, to be able to avoid that maybe. And so that way you're not, if you're not getting out of joint, hey, you're not telling them, hey, knock it off right now, which they may rightfully say, mind your own damn business. We're not going to, we're going to freeze you out at work, but just say, caution them, right? Hey, maybe this is fine for off hours. Just make sure you don't take it back to the office or whatever. And
I think that is a interjection that would stand in the employer's benefit down the road. I mean, at the end of the day, whether you want to or not, you can't control what people do at home, whatever. But you're saying, hey, this is not tolerated at work, and we're not going to tolerate it at work. Yeah. All right. Retaliation, like I said, goes to protected activity, either participation, what's called participation, or opposition. Participation is blatant. They filed a lawsuit. They filed an EOC charge. Opposition is sort of this more ambiguous conduct. I shouldn't say more ambiguous conduct, but it can be. So raising a complaint at the bar where the underlying discrimination might not necessarily be actionable. But you also have more vague forms of opposition. I've seen retaliation claims where someone would just leave the room every time, and they allege that to be opposition. It was held not to be, but there was that argument. I think it's important to see this as very broad. I don't hesitate for a second to believe that if a situation like that was presented, if someone walking out every time, that our Supreme Court might consider that opposition under the WLAD. As some of you may be aware, for example, the case is escaping me, but the WLAD has an employer size threshold in the text of the statute. That threshold has been essentially written out by the Supreme Court, who said that the underlying policy of the WLAD is violated in the context of a wrongful discharge claim, but by termination, regardless of the size of the employer, contrary to what the legislature itself said. And so I think in general, they will read this language very broadly. It can also be supporting another employee's complaining on behalf of someone else. It can go pretty far. Rex? So again, protected activity in general takes a lot of forms within or without the discrimination context. Retaliation can also occur in the context of a request for reasonable accommodation, for filing a workers' comp complaint, for reporting an injury at work, complaining about wages. Some statutes, many of that activity I just mentioned is specific. There are specific retaliation provisions in statute. But we also do have wrongful discharge claims where someone is able to articulate some other public policy of the state that doesn't necessarily carry a retaliation cause of action, but can imply one through that tort. So if someone does something that is protected at law and suffers for it at work, there can be consequences. Rex? I really wish I had this in front of me. My eyes are fading me. Yeah. Well, I don't want to have my head turned to all of you. But an adverse employment action, like we've talked about, can be a whole lot of things, including being frozen out of a meeting, but it has to be material in some way. So I often see allegations about someone getting cold-shouldered in the hallways. That's not necessarily an adverse employment action unless it's actually impacting the work available to someone, like in that hypothetical. Although with that said, you can have a retaliatory hostile work environment. Thank you very much. a retaliatory hostile work environment. Slowly like building a castle up in front of me. Uh, uh, where these comments are so frequent or severe. Someone, I don't know, gets assaulted for having rocked the boat. And so those are possibilities. Rex. So if we look at an example, you're getting close to the hour and a half. But Bob complains that Alf has been using sexually explicit language, stories during team meetings that Alf leads. HR acts on Bob's complaint, tells him that it's been resolved. But then Alf, there we go, stops inviting Bob to team meetings to avoid offending him, and because Bob didn't really need to be there anyways. What would you do in that context? Let's say that you're a colleague of Bob's, you're at his level. Or a colleague of Alf's at a more supervisory level.
Well, if I'm general counsel of Bob's company or in-house counsel, I would refrain from smacking him in the head, but I would tell him, you're retaliating against Alf.
Yep.
Don't do that.
Yep. What about the second question? What if there's a determination that maybe he didn't really need to be in those meetings?
He does now.
Yeah, I think that's exactly the right answer. Yep. No, I agree. All right.
Sometimes you just have to ask your client if they look good in orange.
Well, it seems like then the question would be, well, why was he going there or why were you inviting him before and not now? You know, because that review seems to be like, well, okay, did function, role change, input, expertise, whatever, that needed or whatever. Okay, if there's a legitimate reason, then maybe okay, but still, step one should probably been Kevin's advice.
Yeah, and so much of this is optics from the litigation perspective. I mean, if something's happening a couple weeks apart, even if you don't think it has anything to do with the other, it's going to look like it did. So I've often had cases where someone's position gets eliminated. Maybe you've been talking about a restructuring for a long time, but it also happens to be a week after they raised the sexual harassment claim.
So I mean, just kind of go back to your previous example in the restaurant, and you overhear the folks, and it's like here in this situation, it seemed like the kind of the developed scenario was that the person who spoke up to the individuals who had the offending conduct in the first place then is being retaliated against him or herself by the offenders in the first place. And it seems like, a potential fact pattern to your most recent kind of scenario where you were contemplating restructuring anyway, and that some positions were going to be eliminated. The individuals like, oh, well, if that individual is aware of what's going on and they find some pretext to lodge a complaint in advance of that, then doing a preemptive complaint to be able to kind of substantiate or to show the retaliation when in fact they had some inkling or understanding that it may happen. I don't think that's probably that uncommon or a far-fetched scenario, but it seems like that's something that you would want to kind of be considering.
Yeah, no, I as a defense lawyer, I have my cynicism, and those situations do happen. I mean, the advice I would give it to my client is sleep on it. Like, wait, document and wait. And sometimes the waiting isn't fun, but yeah. All right.
I was looking at that second question.
Yeah, please.
Because of the fact pattern above, I mean, are you now in a box? And I'm looking at this as if I'm an authority who can decide one way or the other. I can neither tell them you have to, but if you actually did that review, and you might even look to see, okay, why were you inviting him in the first place?
Yeah.
But are you stuck now? because the way that the question reads, you review the team and determine that Bob really, you didn't say, shouldn't be
Yeah.
in the team meetings. Now the question becomes, well, Bob shouldn't be. Is it a matter of telling Bob, okay, here's the deal, but here's what, here's why, but I will keep watching to make sure this isn't a recurring thing.
Yeah.
Because I'm just saying, but because I'm just wondering if you determine that he shouldn't be,
Mm-hmm.
and you're not in the mix.
Yeah.
And you understand this. I mean, I would have a concern about putting Bob in the team anyway, just because, even though they're really, you also concluded to the contrary.
Well, I think, yeah, no, I think it's a tough one. And the one point I would say, and then it sounds like we have some thoughts from you all, is why are you reviewing this at this point anyways? Are you reviewing that after all of this has happened? Now you're examining whether Bob should have been there in the first place. I think would be suspect.
Well, the way I read this, I'm reading this, that
Yeah.
Bob has actually, I've become aware that
Mhm.
Bob has been frozen out.
Yeah.
Now, he's
Yeah.
either been frozen out and Bob is shown, I've become aware of it. That's why I did the review. I did the review
Mm-hmm.
to do my due diligence
Mhm.
that Bob was not being retaliated against.
Yeah.
What I come to the conclusion of
The
is
same.
that Bob, you shouldn't have been there in the first place. But I am aware of this, and like I said, I'm giving Bob the information because I'm just wondering, again, are you just stuck? Because the whole point when we're talking about the other things, the whole point is, it is not that you did nothing, you actually did something. You actually went to check it out
Mm-hmm.
to see what the story is, and at the end of the story, you determine as a manager or director, Bob, you shouldn't, because that's the way you've written this, shouldn't be in the team meetings anyway
Yeah.
for that thing.
Yeah. I mean, I think at the end of the day, at least for a while, you were stuck. I think that, yeah, if you're reviewing Bob's complaint and the end result is to kick Bob out or to leave Bob out, yeah, I think that would be a tough position, even if it's not a choice that you would have made in the abstract. But I'd love to hear the.
Well, I was just gonna add, I mean, I think it's a risk analysis, and you can argue that this was made for other reasons and you can document it, but the question is, what's Bob's perception gonna be? And is he gonna persuade other people to his perception? And so is the cost of including him in those meetings so great that it's not worth the benefit of just including him in those meetings to avoid, again, running from the gray area? Like,
Yeah.
what's your advice, Lori? Like,
Don't create issues.
don't create issues.
But is some of
Wish I
this,
could just tell all my clients that.
but is your communication not just to Bob, but also to Alf and the rest of that team, that you are now, not Tom in the bar, but you are now saying, straighten up, we don't tolerate this. I'm actually writing this up and I'm warning you, don't go down this path again. I mean, because some of this is communicating to Bob what you might decide to do, but it's also communicating to Alf and company,
Stop
that,
creating issues.
yeah.
Yeah.
Well, I was just going to say the economically efficient thing to do is, look, Alf, you've created a mess. And, maybe Bob shouldn't be in the team or whatever, but this is the freaking mess you created.
Yep.
Bob is staying there, period. And, if part of the concern is, oh, Bob's going to be ratting you out for what you're doing, that's tough. But Alf, you created this mess. Or maybe I guess the snarky side of me would say, if you go ahead and just give me a bond that will fund the litigation costs.
Well, like was mentioned earlier, there's limits to the indemnification that you all enjoy. Yeah. All right, we are almost at the end here, and I just wanted to touch on your role, although we've talked about that throughout. Yeah, Rex, let's go to the next. I don't think we're going to be able to touch so much on all of these, but I think they speak for themselves. So just have a good sense of your BOG policies, of the WSBA policies. They are thankfully more protective of both you all and of your volunteers and staff than the law is. I mean, you shouldn't have to sue to have a positive, inclusive work environment, and your policies reflect that. Look for warning signs. I think we've all talked about that. That includes as bystanders, but you are, at the end of the day, from a legal perspective, from at least under state law, not necessarily ever a bystander. I mean, maybe with each other, but not with WSBA staff. That your actions or failures to act carry potential consequences, even when you're not involved directly. To the extent you're called upon, to the extent that goes beyond the staff level, handling complaints, reporting what you see as needed. Some of these responsibilities go more to, I mean, traditional on the ground managers, which many of you may be in your firms, but they do translate in their own way to your collective supervisory position as our BOG, which as a member, I'm grateful to have folks who take this seriously in this room today. And I think you all play a big role in not just shaping this organization, but practice in this state, and hopefully showing the folks outside our practice that lawyers aren't all bad. I really appreciate your participation and engagement and the chance to be here with you all today. Thank you.
Thank you so much.
Could we put that last slide back up, please? I was just gonna make a friendly proposed amendment to your slide to not, for the purpose of inclusivity, not have all the hands be skinny white guys under 40.
They are, yeah, definitely all white, exceptionally skinny. Yeah. Yeah.
Under 40, those aren't my hands.
Well, I'll call you to model for a couple of them next time. I mean, we don't have to put it up there, but just have thrown up my email. I'm at Fisher Phillips if anyone wants to get in contact. Thank you all.
Thank you.
So we're going to take a break for 15 minutes.